Good morning. Good morning, Mr. Brown. Are you present?
Maybe try Mr. Goldsmith.
Yeah, just looking from a video. Video, there we are.
There we are. Thank you. Good morning, Ron Crosby, the chair of the hearing panel. So you've got the floor, and you're the first up. Thank you.
Thank you, members of the panel. I circulated yesterday to the hearings administrator some 3 pages of legal submissions. I hope you've received those.
Yes, we have indeed. So it's Mr. Goldsmith, is it? I'm talking about
Goldsmith, yes.
indeed. Yes, we received those. Thank you. We've got those before us.
Thank you. Well, I'm just going to speak to those.
Thank you.
And you'll see the outset I say I appear for Waterfall Park Developments Limited, and also add in there Boxer Hill Trust. And the concerns of both of those parties in this hearing are limited to the provisions relating to rural lifestyle, in particular the direction that lifestyle development be limited to locations identified through strategic planning or zoning. And secondly, sorry, turn my phone off. Secondly, that rural lifestyle development is limited to land adjacent to urban areas. And I've set out in paragraph 2 the 4 provisions which are being addressed. I've put them together. Mr. Brown separately. I put them together because they show a picture. Just to take you through them, development in rural areas occurs in a way that only provides for rural lifestyle development in locations identified through strategic planning or zoning. Management of rural areas directs rural lifestyle development to areas zoned for that purpose. And then FDP8, establishment of rural lifestyle zones only occurs where the land is adjacent to existing or planned urban areas and ready access to employment and services available. And then environmental result anticipated, all new rural lifestyle development occurs within areas zoned for this purpose. So you put all those together and you're interested in rural lifestyle development. It's only zoned land. Not possible to have an individual rural lifestyle lot, as has commonly been the practice throughout the region over the past decade, and only near or adjacent to urban areas. Now, that combination of provisions, it's highly directive, it's prescriptive, there's very little wiggle room, and it is a radical change in direction for rural lifestyle development. And the questions I'm about to pose could almost be summarized in one question, where I ask, what is the issue of concern in an RMA context that leads to or justifies this radical change in policy direction? What's the problem that's being solved? So I go over the page. I say in paragraph 3 that I raised some questions about the provisions. I'm just going to ask these questions, but I submit the panel needs to give consideration to them when determining the appropriateness of these provisions. I start off by noting, interestingly, that all of the provisions sit within a chapter entitled UFD Urban Form and Development. How the provisions relate to that heading is beyond me. And why are the provisions in this chapter? Now, this could just be a locational thing, but surely the district plan should give guidance to lay people and others who are trying to read it. And if you're looking for rural lifestyle provisions and you're looking at the contents, that chapter heading doesn't help you at all. And I say if these provisions were removed or amended as recommended by Mr. Brown, the balance of the chapter would sit comfortably under that heading. That's actually not quite true. I realise there are 2 or 3 provisions relating to protection of rural soils sitting in a chapter entitled Urban Form and Development. So I'm not quite sure how that fits. Paragraph 5. I ask whether any thought has been given to the consequential inconsistency which will arise between the provisions, and it's my collective term for those 4 provisions, and the existing situation on the ground as far as rural lifestyle development within the region is concerned. And I look at, just highlight rural lifestyle zoning. Well, there are zones, little zones of rural lifestyle development scattered all over the region, not necessarily beside urban areas. They're out in the rural areas where rural lifestyle living usually wants to be. In this individual rural lifestyle development, I mean, there have been people applying for consent for 1 house or 2 houses or 3 houses in the rural area in the Queenstown Lakes District. In the 35 years I've been practicing RM law in that district. And there was rural lifestyle development scattered everywhere. And then we have, the realities of development within the region. This region, and the Queenstown Lakes District in particular, smaller urban areas, not cities, where developable land is few and far between, many geographical constraints, and existing rural living development that is widespread. So you end up with, there's a danger of ending up with a regional plan and provisions in a regional plan which do not in any way reflect the reality on the ground. Now, I appreciate that regional plans can take a new direction and that they're not bound by the past. There's case law on that. The past is a factor, but if you have to go in a new direction to achieve an RMA outcome or result, that's entirely appropriate. But that change in direction must be justified. Otherwise, we're going to end up with a regional plan that doesn't reflect the reality on the ground, and there's no justification for it. Paragraph 6, I just repeat, the provisions considered together are a radical change from past RMA practice within the region. And I ask, what is the RMA justification for that radical change in direction? What's the problem? Where is the Section 32 analysis of the existing situation on the ground and the identification of existing adverse outcomes, cost benefit, sufficient to justify what is a radical change in policy direction? And related to, or possibly flowing from the previous question, back to my first question, what RMA-based objectives does this radical change in policy direction seek to achieve? Why can't you have an individual application for a house in the country for rural lifestyle purposes? What's the problem? Why can't you have a rural lifestyle zone that is not near a town? That's logically where they are. They're not near towns. I've only got a few minutes. Those are my questions. I'm inviting the panel to answer them because for the life of me, for what I've looked through, I can't find the answers. Then UFDP 8, policy 8, I've got some specific questions. I first referred to the first half of policy P8.1. Just turning back to my page 2, down towards the bottom, UFDP 8. Number 1, the first half says the land is adjacent to existing or planned urban areas. That's the first half. Now, assuming there are some, first of all, I ask what RMA or regional plan objectives are assisted to be achieved by that direction, which cannot be achieved by other provisions within the plan without such a direction. And what I'm saying here is, well, if your concerns are landscape, there's oodles of provisions that deal with landscape and protecting landscapes. If your concerns are the protection of highly productive land, we now have the MPS HPL, which overrides everything, and there are also provisions protecting productive land. If your concern is efficient provision of infrastructure, there's plenty of provisions relating to infrastructure. If your concern is climate change or maybe carbon emissions, you're worried about people driving too far, well, you could address those by having rules that say rural lifestyle development must have solar panels, must use electric cars, must have chargeable ability to charge those cars. So they're self-sufficient in transport energy and don't burn any carbon. You don't need this radical direction for carbon. There are probably other things, but my point is that the various values and issues that need to be protected or looked after are all addressed elsewhere. So what does this provision requiring rural lifestyle zoning to be adjacent to an urban area, what does it achieve? What's its point? That's my questions on the first half of the UFDP 8. The second half of UFDP 8 says, and ready access to employment and services is available. I'm up to paragraph, my last page, clause 10, paragraph 10. What does the second half of policy P8.1 mean? What does it achieve? And can it be implemented? I mean, think about the words, ready access to employment and services. Anybody in Otago who has a car that works has ready access to employment and services. You just get in your car and drive it. So if that phrase is to have any meaning, someone's going to start putting interpretations on it. They're going to say, oh, ready access means within walking distance. Ready access means within the urban design 15-minute walking neighbourhood. Or ready access means, oh, within 20 minutes drive. Well, you can't put any of those glosses on those words because legally you can't. Legally, you're stuck with ready access to employment and services. So imagine the debate when you come along with your application for a rural lifestyle zone and you've got to establish that it gives ready access to services and employment. I mean, does it mean the services and employment have to be inside the urban area that the rural lifestyle zone is going to be next to? It doesn't make sense. It's entirely illogical. So what does that second half of that policy mean? And we're submitting that policy one should be deleted completely. Paragraph 11 has consideration been given to the clear conflict between P8.1 and P8.2. And just to remind you, P8.2 is the P8.2 is the direction that rural lifestyle development, which must be near an urban area, must avoid land identified for future urban development in the plan or land reasonably likely to be required for future urban development, not even in the plan. So imagine when someone comes along with their application for a rural lifestyle zone beside an urban area, and they immediately got to show that, well, this land might never be used for urban expansion at any time in the future. Well, how are you going to prove that? Because urban areas, they aren't all going to expand at the same time. Who knows which ones are going to expand first and whether you need them for urban. I mean, it's a very difficult situation. So your policy 1 and policy 2 are likely to create very clear conflicts. In paragraph 12, I ask, is it appropriate plan drafting to create such a clear potential conflict from the outset? Paragraph 13, I ask, is it possible that policy P8.2 effectively negates policy P8.1 in most factual situations that are likely to arise? I mean, if you have to have your rural lifestyle zone adjacent to an urban area, then there's got to be a high likelihood that land adjacent to an urban area, right around the edge, is potentially suitable for urban intensification. You can build houses almost anywhere these days. Look at Wellington. So does 8.2 effectively negate policy 8.1 from a practical point of view, which means the regional plan is saying, sorry, no rural lifestyle development, full stop. And in paragraph 14, I say, where is the RMA justification for that draconian outcome? And now I look at the situation, let's just say you've got a factual situation where policies P8.1 and P8.2 can both be achieved. Does that create an almost inevitable future conflict along the relevant boundary between urban and rural lifestyle zoning? And I've referred you to my final page, attached copy. It's just an example. It's QLDC Operative District Plan, Planning Map 30. If you turn to that last page, it's got to turn it sideways, it's Lake Hayes, and you'll see, if you hold a portrait, the top is orange, that's shot of the country. Below it is yellow and green, which is Lake Hayes Estate. And if you look carefully, there's a yellow center and a green around the outside, a ring of green. When that land was zoned in 1998, there were no houses there. The council, in its wisdom, created a yellow urban centre with a ring of rural residential around the outside, in accordance with what one theory of urban development, which is that you have a transition zone that bleeds between the urban and the rural. The other ideological theory, of course, is the English version of you draw a line in the sand and you build the houses with a line in the sand and you have a field over the fence. But when that zoning was put in place, there wasn't a house there, or 2 or 3, and there was a yellow centre and a green urban residential ring. Well, the green urban rural residential didn't last 5 minutes. And you can see, probably too small to see, but if you blow up plan change, that map 30, you can actually see all the sections, all the subdivisions are there. Yellow and green, all developed for urban. Because what happens is the services all get extended to the urban boundary. And then across the boundary in the rural lifestyle area, you've got land that can be developed for housing with services just over the fence. And those boundaries, they almost inevitably collapse. The pressure from the urban with the services available goes over the boundary and overrides the rural lifestyle. And this is just one example of how that happens. So paragraph 16, I say, is it wise or appropriate to have provisions which create that potential future conflict? And I want to add one more verbally, 17. To the best of my knowledge, there are no current district plan provisions or district plans in the region, 5 districts, I think, which have provisions which restrict rural lifestyle development in the way that's proposed. I'm most familiar with the Queenstown Lakes District, where in most of the rural area, rural lifestyle development is a discretionary activity. And you've got to get through a whole bunch of hurdles to be able to build a house in the country. Mostly landscape, there are other hurdles. It's pretty hard, but it's discretionary. And the district plan says, well, if you can get through the hurdles, you can have your house. So I don't think any of the other districts have planning provisions that in any way reflect what's now proposed. So what that means, if these provisions are implemented, every district's then got to go out and do a big plan change to change its provisions to prevent rural lifestyle living as directed by the region. That's a huge cost. And that'll result in hearings with grumpy landowners coming along to complain about these restrictions, and the council saying, sorry, our hands are tied, we're just implementing regional direction. And that doesn't do anybody any good. So fundamentally, at the moment on the ground, in some cases after extensive plan review processes, I mean, Queenstown Lakes is in the year 7 or 8 or 9 of its review, getting towards the end. Others are at different stages. But nowhere in any of the districts have the districts identified an issue or concern that would justify provisions this directive and this restrictive. They didn't identify a problem that requires this control. So if the districts haven't identified a problem, why is the region identifying the problem? And what is the problem that's being addressed? Those are my submissions. Members of the panel, I'm happy to answer any questions. Otherwise, I'll pass over to Mr. Brown to answer any questions about his evidence.
Thank you, Mr. Goldsmith, and thank you for posing the questions to the panel, but I can assure you the panel won't be answering you today. And they're very apposite questions, though, and ones that require consideration. They will doubtless, I imagine, be responded one way or another by the regional council in its reply. So it's helpful the way that you framed it, because it raises a series of questions which we, to a greater or lesser extent, have touched on ourselves with other witnesses. But I'll turn to Mr. Cubitt first to see if there are any questions.
Thank you, Mr. Goldsmith. Probably not really too many questions for you because they're probably more relevant to Mr. Brown, I guess, but I can answer actually one of your questions around current district plans. I think you're right to a degree, but I think probably Dunedin City is probably quite restrictive in the rural zone around rural lifestyle ad hoc, if I could use that word. But the concern that's been raised with us around that more lifestyle development that's provided by rules within a zone as opposed to a zone itself has been the reverse sensitivity concern. and there are a number of industries quite concerned around horticulture. New Zealand is probably the main submitter around that issue, but I take it from your submissions, and because you've practiced in Queenstown for a long time, it probably hasn't arisen as much there as, say, it would in Central Otago.
I think it's fair to say that certainly in the Queensland Lakes District, there's not a lot of farming happening left, and the reverse sensitivity in relation to farming activities that doesn't arise. In fact, I can very rarely remember a reverse sensitivity issue arising in relation to farming activities. In fact, usually it's the other way. Usually it's the other way around. Usually, except when there are grapevines and wind machines and bird scaring devices, does have issues. But certainly in the Queenstown Lakes District, that issue is dealt with by provisions for reverse sensitivity. And there are hearings where people who want houses up against the farmers next door, the grape growers next door, and they're dealt with through separation distances or covenants or whatever. So it isn't a big issue as I see it in the Queenstown Lakes District. Now, it may be an issue in another district or where farming is more prevalent, but I would then ask the question, well, why impose a solution on Queenstown Lakes District that is actually being driven by another district? And it isn't a problem in the Queenstown Lakes.
Yeah, I guess you've kind of answered my second phase of that question, is around how it is dealt with through the consent process. But then leading into that last comment, I guess what you've raised there really is this a region-wide resource management issue that should be dealt with from a legal perspective, by a regional policy statement, which sets an overarching approach. Well, I take from your submissions that you don't believe that's the case. It may be an issue in some districts, but let them deal with it.
Yes, I mean, there seems to be an alternative pathway here somewhere that allows the consideration of individuals or whatever. And as you've been talking, I've just remembered, and I'm sure we can send it to you if you like. There was a judgment issued, environmental court judgment issued, I think about a month ago, on a battle in the Gibbston Valley between a proposed rural lifestyle development and the vineyard owner next door, and it turned on reverse sensitivity and consent was refused. And that judgment's about a month or two months ago. So it is a live issue. It is dealt with, and in that situation, the rural living didn't get there.
Yeah, I would be interested to see that decision if we could get a copy of that.
I'll arrange that to be sent through to the hearing administrator.
Thank you. I know that's all questions I had. Thank you.
Yeah. I'm glad that you recognise the difference with viticulture, because certainly coming from Marlborough, reverse sensitivity issues have been a massive issue up there. I remember sitting as a commissioner hearing submissions in relation to a variation proposed, plan change rather, proposed in respect of frost fans that went for weeks, and the great majority of people appearing before us were in fact rural lifestyle owners, which to me certainly suggested that there was a major issue potentially that arose in respect of that particular activity. The Gibbston one that you've just referred to, I agree with Mr. Cubitt. We'd be very interested in seeing that decision. So thanks for offering that to the hearings administrator. The only other observation I just wanted to raise with you was that from time to time, whether it was in practice on one side or sitting as commissioner on the other, various servicing issues have arisen in relation to various regions that I've sat in relation to either potable water services, sewage, methods of sewage treatment, stormwater issues, provision of power, provision of telecom and internet connection. All of those services are issues that arise from time to time with rural lifestyles, Do they cause problems in your area?
I guess my first response is yes, those issues do arise from time to time. It depends on the site, but every application for rural lifestyle development has to address those issues, and there are provisions in the plan that you don't get consent unless you do address those issues. I mean, you've got to protect waterways these days, wastewater disposal inevitably to ground, usually entirely safely, telecommunications, who's got a landline these days, power is usually available, or you can be self-sufficient. My point is, you don't need this hammer to crack those little nuts. Those little nuts are already cracked in the district plan because you can't get consent for a house unless you deal with them.
Right. So you say as a practitioner that those are the very sorts of issues that you ensure your client or your client's experts have addressed.
Absolutely. I mean, almost rule number one of my practice is start with infrastructure. Whether it's a resource consent or a plan change, start with infrastructure. You've got to have the infrastructure.
No, thank you very much, Mr. Goldsmith.
Sorry, is it?
Yes, so you're calling Mr. Brown now.
I'm calling Mr. Brown. Panel. I guess I should ask Mr. Brown, you'll confirm that your name and qualifications are as detailed in your written evidence and that your evidence is true and correct?
I've just unmuted myself to make sure people can hear me.
We just heard you just then, Mr. Brown, so you're coming through clearly.
Right, thank you, Mr. Chairman. Answer to your question, yes, Mr. Goldsmith.
Anything else you want to add to your evidence at all, Mr. Brown?
I've prepared just a very small synopsis of it. If I may read that out, or I'm happy just to answer questions.
Now, look, if you've got a short synopsis, if you could provide that to us.
Thank you. I'll start with policy UFD P8. My paragraph 2.2 sets out the changes I consider are necessary to this policy. They are delete limb 1, and in limb 2, delete the reference to limb 1. And my key reasons for this are, firstly, those that I outline in my paragraphs 2.5 to 2.8. And when factoring in all of the constraints on development, for example, including imperatives for landscape, ecology, highly productive land, and reverse sensitivity, as well as this constraint regarding adjacency to urban areas, this seriously limits opportunity for new rural lifestyle developments. It would unnecessarily prevent rural lifestyle activities where it may otherwise be the most appropriate zoning of the land in question when put to the tests under section 32, whether or not the land is adjacent to existing or planned urban areas. And taking into account all of the relevant considerations, there is no justification in my mind for land to be disqualified from rural lifestyle just because it is not adjacent to an urban area. Secondly, if land adjacent to an urban area is suitable for rural lifestyle development when examined under the various relevant variables, that is landscape and so on, then it is likely it is suitable for urban development, which is in the context of districts such as Queenstown, where land suitable for urban development is a very finite resource, a far more efficient use of that land is urban than rural lifestyle. Thirdly, this raises the issue of the juxtaposing of limb 1 and limb 2 in the policy, which clearly do not sit amicably together, as Mr. Goldsmith is talking about. And overall on policy UFD P8, any case for new or extended rural lifestyle areas should be based on the opportunities and constraints inherent in a particular area and not forced to be adjacent to an urban area. On UFD 04, I consider the changes I set out in my paragraph 3.2 are necessary, so that rural lifestyle as a development form is not just areas zoned for that purpose. It also includes small-scale ad hoc rural living in rural areas outside dedicated rural lifestyle zones, which often have a consenting pathway for subdivision and development. My changes differentiate between the two forms and do not foreclose the potential for the small-scale form. District plans would then be able to address the specifics of the consenting pathway. For example, the Queenstown Lakes District Rural Zone, which imposes a discretionary consenting pathway for new rural living, but subject to a very stringent assessment on a range of factors, particularly landscape, and as Mr. Goldsmith's drawn your attention to in the Gibbston area, reverse sensitivity is an issue in the objectives, policies and rules. On policy UFDP 7, it follows from my discussion above that this policy is unnecessary and it should be deleted. And finally, although I didn't mention it in my evidence, UFD anticipated environmental results clause 11, based on my discussion above, this should be expanded to recognise small-scale rural lifestyle as well as the formal zones for rural lifestyle. And I suggest a modification to this clause that would read something along the lines of, all new rural lifestyle development occurs within areas zoned for this use or otherwise recognised through district plan provisions. That's my synopsis, Mr. Chair, so I'm happy to answer any questions.
Just before I ask other commissioners, that last piece that you just added, I think was a question that I'd sort of posed myself when I read your evidence. That's not within your body of evidence, I wouldn't think.
No, it's not.
So just read it out a bit more slowly. Where are you saying?
Oh, certainly. So this is UFD AER 11.
So if I can break in, it's in my, it's the last one on page 2 of my submissions.
Right, right.
UFD AER 11.
So my wording, it currently reads all new rural lifestyle development occurs within areas zoned for this use. And my addition would be, or otherwise recognised through district plan provisions.
Possibly the word enabled rather than recognised, Mr. Brown, possibly?
Oh, possibly, or recognised. I think in using the term recognised, it may be that something might be non-complying because it doesn't meet a standard, in which case it wouldn't really be enabled. But the process would still recognise it, and there's a number of non-complying applications for rural lifestyle development that get granted. So recognise sort of covers those as well as those that would otherwise meet an enabling rule.
Accept that.
Mr. Brown. Mr. Kibble.
Thank you, Mr. Brown. Just on that last provision you were talking about, AER 11, would you mind actually flicking through a copy of your statement to Kate, just so we could actually have the exact wordings of that? But I guess the issue there is, in my way of thinking, AER 11 is kind of irrelevant at the moment because we need to work out the objectives and policies first. So whatever happens there will impact on AER 11. And you would have heard my questions to Mr. Goldsmith around reverse sensitivity, etc. In that context, a number of submitters have also raised the fact that rural activities provided for in the rural area should have a functional operational need. I'm wondering if you have a comment on that and how that would play out in terms of rules around rural residential development, which I guess by definition needs to be in a rural area. Also, maybe put it in the context of the New Zealand planning standards, that very prescriptive document that's come out of Wellington recently, with those zone descriptors that talk about incompatibility, etc. How does your framework fit within that?
Well, first of all, yes, by definition, the rural lifestyle development, which is the term used in the standards, needs to be rural. It needs to be rural because the sorts of people that live on these properties want to be in a rural area. They don't want to be in an urban area. They may not want to even be in a peri-urban area, which is what rural lifestyle adjacent to an urban area would be. And areas such as Dalefield in Queenstown, a long-established rural lifestyle area, average lot sizes, sort of, half a hectare up to maybe 10 hectares. Suiting people who want ruralness in their environment, but don't want to be necessarily farming per se. Maybe hobby farming, running a horse, having a very large garden, which they need good land for. Those sorts of activities, which if they can pass the tests, the real tests, landscape, reverse sensitivity, ecology, highly productive land, fresh water, and so on. If they can pass those, I don't see any reason why they should be constrained almost artificially in the way that the current wording of some of these policies would do. The national standards, I'd need to refresh myself on those as to how these things might be constrained. But certainly, my view is that rural lifestyle is still an essential component of rural activities, and needing to be in a rural area. And as long as all of the other variables are addressed properly in district plan rules, and of course governed by regional policy statement provisions, then I think there should still be a consenting pathway for those.
Okay, thank you. Because I'm just trying to work out in my own mind whether those planning standards actually direct that directive that they require this sort of stuff to be in a rural residential zone, or it can be in a rural zone, because we have had some planning units suggest that they should be in a zone, not in the rural zone itself, based on that compatibility and functional need thing. Yeah, I guess that's probably all I had. Thank you, Mr. Brown. I understand your evidence. That's very clear. So thank you for that.
Thank you.
Just out of interest, Mr. Brown, and I'm not trying to be unfair or trap you at all, but were you involved at Queenstown District Lakes at the time of those development zonings that were shown to us by Mr. Goldsmith at planning map number 30?
Not on those specifically. I think they came in by way of a submission, which I wasn't involved in. I was the district planner when that plan was notified. Those zonings came in by way of submission, and I wasn't involved in the hearings of those.
Mr. Goldsmith described the outcome as being really very short in duration before the green rural lifestyle areas became in reality urban. Would you agree with that description?
Yes, I couldn't tell you how short was, but yes, there was. It very quickly became effectively a dormitory suburb for Queenstown.
I was counsel for the landowner.
Right.
Members of the panel.
Right. Yeah, like Mr. Cubit, Mr. Brown, I when I was reading your evidence, and it was why I asked that question right at the start about whether you'd added those extra words, I was looking for those in a policy being proposed by you. So should that be the better setting if there was to be that provision made that you are seeking?
Sorry, for which?
When you provided those additional words that you suggested be placed in UFDA 11.
Oh, yes.
So both Mr. Cubitt and I are really suggesting that that sort of provision would need to be in a policy, wouldn't it?
Well, I had been, my thinking there was that the consenting pathway style rural lifestyle would still be captured with my changes by limb 3 of objective 4.
I just give with me while I turn to that.
Because it would, and that's on page 10 of my statement, my evidence. My in blue, my suggested track changes to limb 3 of objective 4, where it provides for rural lifestyle zones, but also activities that are sensitive to primary production and rural industry, which I had thought would capture rural lifestyle development in its more small scale, non-zoned form.
Oh, I see.
Now, if that would need to be enunciated a little more directly, I'd be happy to provide some words for that. But I was lumping in rural lifestyle generally as in that bundle of activities that are sensitive to primary production and which but could still be in rural areas, subject to meeting all of the other tests.
Yeah, I think it's a pretty indirect way of identifying that activity. I think if you and you've made that offer to send your synopsis through to the hearings administrator, I think if you could add whatever wording change you were suggesting to that subclause 3 of 04, that would be helpful.
Indeed, I will.
Thank you. Well, that I think is all that I needed to ask you about. Brown, I think about this. Oh yes, going back to that 3, it's the location of the. No, it's all right. I'll wait and see what you come up with. I was just querying the location of the word only, and whether that was in the right location or whether it should be further down 3 lines from the bottom, only in locations identified. But anyway, you'll turn your mind to that when you do your wording. So thank you very much, Mr. Brown.
Thank you.
Thank you, Mr. Goldsmith. That's, I think, winds it up as far as your commission's concerned.
Yes, thank you. Thank you, members of the panel.
Thank you.
And that concludes the hearing for this week.
Thank you. Oh. Should we take